Good afternoon, everybody. Thank you for joining us. Just as people are kind of registering and coming onto the session, I'll just draw your attention to some of Surrey Law Society's forthcoming training and events. We've got 3 sessions on the screen now. As with last year, the Society is running a hybrid programme of training. So we've got free webinars throughout the year, plus some longer online courses, and some half-day in-person training courses, which we hold at TWM in Guildford. Ordinarily, I would direct you to our website for more information, but as some of you might be aware, our very old website finally decided enough was enough last year and is no longer working. So we are in the final stages of building a brand new site, which hopefully will be live at the end of next week, I think. So the information will be there from then. However, if you want it before, if you'd like the full program and you haven't seen it, then just email myself or Eloise and we'll email it over to you. Moving on to some housekeeping notes. So as you probably heard when you joined, the session's being recorded. It's a webinar, so you can't unmute yourself or put your camera on, but if you'd like to ask the speaker a question, you can do this during the session by using the Q&A box, or at the end of the session, if you raise your hand, we can unmute you and you can speak directly to Karen. I think that's all from my end, so I will stop sharing my screen, Karen, and over to you.
Good afternoon, everyone. It may be other people are joining us as we progress, and these slides will be available for your further consideration, particularly in respect of some of the regulatory aspects that I'm going to cover. I will try and pick up Q&A either as I'm presenting this or hands up, etc. And certainly at the end of what it is that I would like to say, I'd be very happy to have a conversation that's intuitive and flows in terms of questions that arise from what is obviously a very new way of working. So without further ado, and coming live from Anthony Gould's offices in London Bridge, which is where I am today, I'm now going to share my PowerPoint with you. And at this point, I really hope that I get, as I just said to Helen, that I get the right document and don't tune you into something else. Okay, I hope that's come up. One lawyer, one couple, a new way of working for separating and divorcing clients. I'm a consultant at Moore Barlow in Guildford. As I say today, I'm in London Bridge. I'm a mediator and parenting coordinator, which is work outside of the court arena. I am a solicitor, but I don't practice as a solicitor any longer. I'm a PPC, which means I supervise a number of other mediators and practitioners. I'm a trainer. I'm a member of Dispute Resolution Committee, the Future Practice Working Group, which is where we have looked at and developed this model of one lawyer, one couple. I'm a member of the Family Solutions Group, which was coordinated on at the request of Mr. Justice Cobb to look at recommendations and reform for private law children matters. And for the summer and into the autumn and continuing, I'm a member of the Early Resolution Minister of Justice Working Group, looking at MIAMs and measures to strengthen the use of out-of-court processes. As I say, these slides will be available to you after the presentation, and I think those might be helpful for those of you that might need to refer some of these matters to your regulatory colleagues. These are the items that I shall be discussing, and the first really is to look at how we have got to where we have got to. For those of us working in family breakdown, we have had numerous clients come to us over the years that have said, can't you act for us both? We know what the outcome needs to look like. We'd like one person to help us with that. And for so long, practitioners have said, well, look, I can advise and act for one of you, but the other is going to have to go to my colleague down the road, etc. So we know there is a great deal of public appetite for separating and divorcing couples to consider working with a single authoritative qualified professional, reducing then the risk of acrimony, reducing the risk of his lawyer, her lawyer, etc., so that they can get the sort of service and support that they feel would suit them and their family. Previously thought unworkable. In terms of how we've got to where we've got to and the evolution, we've had mediators preparing consent orders. That's often heavily caveated. This is not legal advice. It is not intended to replace legal advice. The recommendation is that you take independent legal advice. That was then followed by SRA guidance that when mediators are also solicitors, they might terminate the mediation retainer and then establish a new retainer as a single lawyer to prepare the consent order reflecting the terms of the mediation. I liken this a little bit to like Mr. Ben, the cartoon. You're then wearing one hat, he goes behind the curtain, he comes out, he's wearing another outfit. We then saw Withers develop their model, which is here, Withers Uncouple, which effectively is mediation with add-ons, early neutral evaluation, private FDR, but with all legal advice being taken outside of the process. We then saw the divorce surgery start to come into this space with their advising the couple process, and that was permitted by their regulatory body, the Bar Standards Board. We've seen the explosion of the unregulated space, most notably amicable. We've seen professionals leaving the regulated space to establish their practices, which typically would say, I am a solicitor, brackets non-practicing. This ABC XYZ family law is not a regulated law practice. We've seen unbundled legal services, where perhaps the couple have come to one lawyer to then prepare a consent order reflecting their negotiated terms. And I think because of all these developments, we took the view that resolution would look again at whether it is possible in the regulated space for one lawyer to provide legal advice to one couple. And after 2 years or so of work, we think that is possible. That process that we have developed, it goes by the working title, which I think actually is a great title, Resolution Together. In looking at the various aspects, we spent a long time and took regulatory advice from Tim Dutton, QC, KC now, of course, I need to amend my notes. And that was recorded in an interactive session, which is here and available. And Tim has been very, very generous with his time as this process and this model, this way of working has developed. We've seen changes outside of just the marketplace moving towards providing a service for a couple. The Divorce, Dissolution and Separation Act 2020 removed fault-based divorce and enables a couple to apply together for their divorce. HMCTS digital access, I think things will continue to develop there. And even since preparing these notes, I understand from Juliet Harvey, Resolutions Chair, that HMCTS will now accept uploaded consent orders under the one lawyer model, which I think is another interesting development. We've seen a move certainly in terms of children matters, but I think generally to seek to remove conflict, particularly recognising the harm to children from ongoing conflict between their parents. And the amicable scheme was endorsed by Mostyn J in the case JK and MK. So the single professional. There is no obligation for family law practitioners to offer this model. It may not be for everyone, and of course it's not going to be suitable for every couple. But the single professional's role here is to facilitate the couple's negotiations, is to provide legal advice on whether the outcome of their negotiations has fallen within the parameters of the lawyer's advice. It is inappropriate for the single lawyer to be involved in substantive negotiations. The mediation community, which of course I represent heavily now, having moved to the entirely out of court space, has some concern that this model sounds very much like mediation light. I don't think it is. I think there are key distinctions between mediation and one lawyer. Mediators provide information, and some of us are quite bold in terms of the level of information, legal information we give. Mediators become involved very much in terms of the negotiations. We roll our sleeves up and we sort of get stuck in. The single lawyer, sole lawyer, one lawyer model is not designed for the professional to become involved substantially in those negotiations, because they risk offending regulatory breaches, etc. It is their role to gather the financial disclosure, to give the parameters in terms of the legal framework, to give a legal view based on the circumstances of the couple's finances and the case in terms of where they feel their case should settle. And then the couple effectively negotiate between themselves. Now, it may be that there's a little bit of light touch assistance from the one lawyer, but if there are substantive negotiations, then that should move out to a mediator, or a mediator come into the one lawyer way of working. And I think that this model lends itself to those of us working in family law to form relationships with one another, so that we can put processes together where clients don't feel they're being pushed from pillar to post. I can do this, I can't do that. But where perhaps they're in the one lawyer, and then if there need to be some quite substantial negotiations, perhaps some risk of a conflict of interest, the one lawyer pauses for a while, and a mediator comes in and deals with that when then hopefully matters are concluded, and the one lawyer closes it out, draws a consent order and lodges it on the portal. Most practitioners say, how on earth do you get around the conflict of interest issue, which is what hitherto had always suggested that this way of working was not going to be possible. And here, and I think this may be helpful for those of you that need to share some of this sort of deeper read with your regulatory colleagues, is perhaps where some of this is going to be helpful to you. The solicitor is usually a fiduciary of their clients, giving rise to a duty of care to act with loyalty and in good faith. A solicitor cannot act for two clients if there is a conflict of interest between them, or a significant risk of such a conflict. However, it is open to clients of solicitors to waive any conflict of interest and to consent to the solicitor acting and or advising, provided that the consent to the solicitor so doing is informed by all the material facts and the clients have provided informed consent. So we recognise that for two or more clients, there can be a real or potential conflict of interest. We recognise that clients have the ability to waive that and do so provided they are informed by all material facts, and that's going to be financial disclosure. And of course, it is possible for them to go away from the one lawyer process and take their own independent legal advice. Informed consent requires the clients to be in possession of all relevant material facts, i.e. everything they need to know before they can make possibly the biggest decisions, certainly financial decisions of their lives. They need to provide each other with that information. And the same high threshold of financial and other relevant disclosure is required in this process, as it is in my mediations, as it is in solicitor negotiations, the court, or in arbitration. At common law, it is possible for parties seeking to separate, divorce, or make arrangements for their children to enter into a relationship with one solicitor, whereby that solicitor provides both parties with advice, provided their consent to his or her so doing is informed. This proposed scheme has, and the documents, and I'll refer to those, has been before the SRA. As we developed this, we sought SRA guidance. There were various meetings. They required a couple of things to be sort of tweaked. I mean, they really were tweaks, dotting I's, crossing T's. And so in terms of the regulatory aspects, the SRA is entirely comfortable and happy in terms of the regulation in terms of this way of working. If the solicitor has obtained informed consent of the clients to act, then the risk of there being a claim in negligence arising out of a conflict, or a significant risk of conflict, is actually strongly reduced. And our view is that if practitioners practice in accordance with the framework that we have established here. If they don't become involved in the substantial negotiations, if they have obtained the client's informed consent, then actually the risk of negligence should be lower than in traditional one client work. The insurers have obviously looked at this, and those that are practicing this do so with their insurer's consent and blessing. And it's hoped that insurers, as this is extended, see that a properly constituted scheme with all relevant facts being considered, so that consent is informed, will consider that there is no greater risk of liability or negligence or breach of fiduciary duty than under current arrangements. If informed consent has been provided, and if the solicitor has discharged his or her duties with reasonable care to both parties, there ought not to be any appreciable risk in terms of liability. And the view of Tim Dutton KC is that although we've referred here to SRA regulations, there is no difference in principle so far as barristers or members of SILACs are concerned when considering duties of common law and of fiduciaries. So one lawyer may be a barrister, may be SILACs, may be a solicitor. This is a very, very important item, and again the notes are quite fulsome because it may be that the various colleagues, partners, department heads, etc. have some real concerns about the regulatory aspects, and particularly the conflict of interest. The SRA Code of Conduct, paragraph 6.2, you cannot act if there is a conflict of interest or a significant risk of conflict, unless, and I think this is really important in undertaking this work, the clients have a substantially common interest, and or they're competing for the same objective. And I think when we are working with separating and divorcing families, they are often, even if they're not entirely aware of it at the get-go, seeking, similar common interests. They often say, we want fairness. Well, of course, that depends which angle you're looking at it. They will say, we want to put our children above everything else. We want to be tax efficient. We don't want to spend all our money on lawyers or going to court. We want something that we feel we can both live with, so that we can then continue to cooperate with one another for the rest of our lives as the only parents our children will ever have. And I think when one's looking at taking on clients in this one lawyer model, time should be spent with the clients individually and together to identify their common interests, their objectives, what I often call guiding objectives and principles. And they are often very aligned in that. When we sought the SRA guidance on conflict, there was a view that a conflict may not arise at all. I think hitherto, when perhaps the husband has rushed off to, I'll promise you the moon and the stars LLP, and the wife to, you can have all the assets in a bag to put them in LLP. Clients are polarized on a best interest basis. We know, working in the family arena, that in terms of children matters, the welfare of the children is put above everything else. And in financial matters, again, the needs of children under 18 are the first consideration, but then we look at a fairness and a system that meets needs. So there may not be any conflict at all. Couples may just need someone to guide them, to help them, to explain the parameters of law, to help them with any practicalities, remortgaging, tax advice, etc., and to formalize their arrangements in a consent order. A suitable couple may have decided to separate amicably, have disclosed their financial and all other relevant information, agreed in principle on their financial settlement, the care of their children, and the financial provision to be made. They present to a single professional, asking the professional to draw up the appropriate agreement or order to reflect the terms they have reached. I mean, they may have done a lot of work with this themselves, and to take legal advice as to whether their terms fall within the parameters which the law provides. And there would appear there to be no significant risk of conflict, actual or perceived. Forgive me. Under such circumstances, the parties can consent to a single lawyer acting and advising, and there is nothing in the SRA Code of Conduct or in common law which prevents them from so doing. Suitability is going to be key in terms of this work. If practitioners are undertaking it, I would certainly recommend that they undertake the resolution together training. In fact, if you wish to use the title resolution together, it is a requirement that that training is taken, although practitioners may decide to use this model, and there's nothing in terms of the regulation or otherwise that can stop them from that. It's not going to be for everyone. Our view is that it is probably best done by perhaps more experienced senior members of the department than perhaps newly qualified for all sorts of reasons. Assessing suitability of the couple is absolutely key. If one or both of the couple refuse to give financial or other relevant disclosure, this process cannot continue. It's inappropriate. If there is a significant power or other balance, it's perhaps inappropriate. If there's coercion or control or a history of abuse, potentially financial or other abuse, this process may not be appropriate, we say. If one party has compromised capacity, is unwell or hindered in some other way, again, that should be a red flag. But notwithstanding that there will certainly be some cases which will not be suitable, we think there are perhaps more that will be suitable than we thought likely, certainly as we develop this. The lawyer has an obligation to make an assessment throughout the conduct of the matter. So even if it looks suitable, but then actually as they're working through, they realise that perhaps the relational aspects are much more complex. There is a history of abuse they weren't made aware of because the couple presented and were very, very keen to use the process. That does not mean it's suitable. And at any stage, the lawyer making their constant assessments as the process develops can and should terminate the retainer. The lawyer must, on the facts of the case, be satisfied that it's reasonable for them to continue to act. This is not an entirely subjective question. A lawyer cannot say in his or her judgment that it would be reasonable for him or her to act, where objectively no reasonable or right-minded lawyer would have reached the same conclusion. So that constant assessment is absolutely key, and not just by their own standards, but perhaps by what their professional colleagues would say when presented with the same set of circumstances. The retainer must be clearly defined to identify precisely what the service is. There must be a statement with the retainer letter that at any point either party may wish to take his or her own separate legal advice, and they're free to do so, and they're not obliged to notify the other person or the one lawyer that they've done so. The lawyer, I make this point again, the lawyer ought not to be doing much or any of the negotiating themselves. That is between the clients, where perhaps the lawyer sort of pulls back and admires from a little bit of distance. But if there are real issues dividing the couple, then it would be inappropriate for that lawyer to become involved in those negotiations. They should probably pause, bring in a mediator, or perhaps refer it out to mediation. And it would be inappropriate for the one lawyer to undertake reserved legal activities. The view is if they're not seeking to exercise any rights of audience, and they wouldn't conduct litigation, etc., then it's highly unlikely that they would be undertaking any reserved activity. This is a fast-changing landscape. I updated these notes last night as hunters have now joined the providers that I'm aware of. There may be others out there. My firm has its model here, Accord. Mills and Reeve have joined this space, separate well together. Jo O'Sullivan at O'Sullivan Family Law, she was an early adopter. I think the earliest adopter is David Lister at Simpson Miller, separating together. He's now moved firm, but I leave that information for you there. Our colleagues at Family Law Partners, Agreeable. Their model is interesting. In every case, they insist that the couple work with their family therapist, Kim Crew, and that is one of the conditions in them working with the couple in this way. Paul Linsell, Boys Turner has this process. Flip, I see this week, have joined this space with their process Settle, and as I say, Hunters, I saw yesterday, have joined there. There's an article here I refer you to that acting for both sides in a divorce may become the norm. Obviously, there's a certain amount of media interest in this and interest in the professional journals, etc. Resolutions timeframe, well, the training is now underway. There are additional training requirements for lawyers that have not worked with a couple, i.e. if they are not mediation trained, if they are not collaboratively trained, then there are essential models of safeguarding to enable those lawyers to understand working with a couple, which is quite a different dynamic to having a sole client. And that training is available on the Resolution website. A full suite of materials is available, I think, for everyone, actually, not just Resolution members, which includes the retainer, the handbook, Resolution Together handbook, documents for your COLP, letters for your insurers, etc. And as I say, that training and development is now being rolled out. That was a fairly quick canter through. These slides will be available, which I hope are helpful to you and to your colleagues. And so I'm very happy to take questions or questions from the floor or in questions and answers. So I think, Helen, we might have the capacity to unmute people if they want to put a question forward or to put something in the chat. And perhaps I could sort of ask whether there's anyone here currently who is offering this or is having meetings with colleagues where they may be in the sort of developmental scoping stage. So I suppose, are there early adopters? Are there, well, I'll just see how this develops and then think about developing our product? I mean, are there some people that, are sort of way behind and think, actually, I'm not sure about this. I don't think that's work I would want to be doing. I don't think it's worth work that my firm would support me in doing. Any comments in the chat? Anything at all? Any signs of life would be good. Oh, thank you. We have a hand. I'm grateful for the hand. Let me, Nigel. Oh, Nigel, I'm not sure I can unmute you. Helen, I'm not sure.
No, Nigel, he'd need to unmute himself, Nigel.
Oh.
If you could unmute yourself, you should be able to speak.
Is that, can you hear me?
Yes, we can. Hello, Nigel.
Oh, yes, very well, thanks, very well. Yes, I'm acting for a couple at the moment who it's a fairly straightforward situation. There are no children and a jointly owned property. I've got to the stage where I've prepared a draft consent order, but in terms of then submitting that to the court, should we try and indicate that the parties are acting in person, or would we put ourselves down as acting for both parties?
Okay. Thank you for putting that to us. They presented to you, obviously, as a couple that has enabled you to take them so far. What's the retainer that you've got with them now, or with one now, Nigel? What sort of, you open the file, whose name is it in, and what is that retainer for them both, or for just one?
So the retainer is in both names.
Yep.
And I've agreed a figure with them for the work I'm undertaking, which is the drafting of the consent order, the D81, and then submitting that to the court on their behalf. They sorted out the divorce proceedings themselves, but obviously didn't feel competent to attempt to put a consent order to the court on financial issues.
Okay. So that sounds to me as though it's a joint retainer. they've presented their proposed settlement to you for you to reflect in legal speak in a consent order and to deal with the formalities.
That's correct, yes.
Okay. Did you give legal advice on their settlement, or are you effectively holding a mirror to it and translating it into an acceptable format of words for the court?
Effectively, that's what I'm doing, but it is a fairly straightforward situation in that it is a 50-50 split. As I say, there are no real other assets other than the property, so there's no issue of pension sharing or anything of that nature. So I felt able to deal with it because it was a relatively straightforward situation.
Yeah, and I think you're providing a service which is absolutely right for those folks. And I think some lawyers have been doing this, whereby they're not providing legal advice to the couple comes to them, this is our settlement, we're not asking you for legal advice upon it, but we want you to translate that into something which we know the court is then hopefully going to rubber stamp. I mean, I think from what you're saying, on the basis that you're not providing legal advice, you're quite within the retainer to prepare the document. I'm sure you've said somewhere, I will reflect the terms of your settlement, upon which I haven't given legal advice, into the required format, phraseology for the court. I'll assist you with the combined D81. And then those two documents, I think they could take off and upload themselves.
Yes, that's probably easier, I think, isn't it? Yeah.
I think it is, because I think it seems to me that what you're doing there is, helping them translate their settlement into a form of words, Matrimonial Causes Act, etc., which then, having done it quite, properly, could hand back to them for them to submit. Yes.
Okay. Well, that's very helpful. Thank you.
It's a pleasure. I mean, having heard what I unbundled here in this, one lawyer providing legal advice, which is not what I think you did with these folks. Do you feel that is something you would consider moving to? I mean, tell me how that feels for you.
I think one has to be very careful because certainly, whilst you may find that an initial approach, the couple want to have something dealt with because clearly in terms of costings, it's going to be cheaper. I think the difficulty is where you have a more complex situation, as matters develop, then I think the risk is that then a conflict will arise. And then you're potentially in difficulty because you've got so far, you've then got to stop. They've then both got to go to separate lawyers. And in the end, the process can end up costing them more money.
Okay.
So I think anything where there is perhaps a more complex situation, I would be very wary of being willing to act as one party on behalf of one solicitor on behalf of both parties.
Okay. What I suppose for some practitioners they will feel is, if you are the one solicitor, obviously it goes without saying, if the process is terminated, that one solicitor can't go on to represent one or either of the parties. They need to go off somewhere else. So do you feel there would be a sort of business consideration that actually doing one lawyer, where I'm not sure the complexities of the financial situation alone would prevent the one lawyer doing the work, but potentially where you think, I don't feel these folks could be aligned in the outcome. I do a certain amount of the work, and some of these muddles are on a fixed fee basis, and then it breaks down, and then I've lost the case completely. There's a commercial business
yes, indeed. I think that is quite realistic, because I think many couples are obviously potentially quite naive regarding the situation, and you've got to then start giving advice, and then it is a situation where you're getting, I would say, into a very difficult situation, because there's a risk of you perhaps inadvertently or unconsciously favouring one party's position over another. And as you rightly say, I think at that point you then have to say, right, you need to go back to mediation or commence mediation if they haven't started it.
Yeah. So I suppose, just as we can see, again, we're all in business, running businesses. We are looking to keep our service relevant to what we think people need and want. I mean, it must be right that, those of us that are legally trained are able to provide the one lawyer way of working, rather than clients making their way out to the unregulated and in some cases dangerous space. It can't be right that the Bar Council can do it and yet lawyers can't. So, I would say we are the people best placed to do this work. But if there is a growing public appetite for this, there is perhaps the business model and business sort of consideration to think, well, maybe for certain clients that come to me that ask for it and are looking at it, I may, if the case is suitable, add this to my skill set, because I risk losing the case. They're going to go down the road and go to someone who is going to provide it.
Yes, I mean, I would agree with you. I think, obviously, I've been in practice for nearly 40 years, so perhaps I grew up more in the adversarial arena. So I've adapted over the years to a much more collaborative approach, but I'm not a member of resolution, because I always felt that to give your best advice to a client, it was the only way to do it was to represent that one client. But I can see there are great advantages if parties are actually fully understanding of their situations and the implications of the decisions they're taking. And in those circumstances, then I think it is possible for one solicitor to act for both parties.
Yeah.
But as you say, I think that you need to make a very clear assessment as early as you can whether that situation would work for that particular couple.
Yeah, I think last time I spoke with David Lister, he'd had 12 or so cases. I think almost all, but not quite, one or two hadn't settled. And then, of course, the one lawyer had needed to be either suspended while they perhaps move into mediation to resolve whatever it was that they couldn't resolve. But for those that have used this, and I do accept we are at the beginning of a new way of working, it has been largely successful, with a lot of sort of consumer confidence and satisfaction. And I say satisfaction, we are in the business of, we are distress purchase. People don't really want to have to use us, but they do. And I think we need to keep the way we work and our offering relevant to, I suppose, a changing landscape, and one where we are moving away from conflict, which doesn't mean we don't resolve difficult issues, doesn't mean we don't have difficult conversations. But I do feel there is a sort of groundswell in terms of the purchasing public that if this way of working is suitable to their case and their circumstances, I think, some people will sort of self-select. And I would hope that in and around Surrey, we have some practitioners who are willing and confident to offer it. And perhaps what we could do is sort of have those people, not necessarily in another pod, but for them to sort of share ideas, what's worked, etc., so that, we can keep this under constant review and I think constant evolution. Thank you, Nigel. Thank you for coming on. I mean, almost 40 years of practice. Still young at heart, still lots to learn, still learning every day.
Well, that's why I'm still doing it.
If the training, appeals, then we'd be delighted to have you.
Right, thank you.
Any other indications or observations from our other colleagues? I mean, if somebody said, I wouldn't do this work, I wouldn't touch it with a barge pole, I can understand that. I hope it's been helpful to give you an overview of where this is. I mean, we are lucky in Surrey that we have a very active family law community, constantly looking to see what is going on, what we can do better. Watching again what our clients require. I mean, one of the depressing things I can remember from years ago is that Surrey is often considered to be the divorce capital of Europe, which is somewhat sort of depressing, but it does require us, I suppose, that do this work to do it ethically, putting the needs of children above everything else. And I think, as the president has said, the tectonic plates are shifting, and I suspect that there will be, more practitioners working in this way and adding this way of working to a range, a sophisticated range of offerings. Unless there are any further questions or observations, I shall thank Helen, who is working the magic behind the scenes. Rita, hello. And just before we ask Helen to close us off, we've a question from Rita. Thank you here, which I hope everyone can see. May I ask at what stage we return the case if mediation fails too? That's an interesting observation. I suppose we've got one lawyer, they've done the disclosure, they've set the scene, they've given legal advice relative to the circumstances of the couple. They've listened to the conversations about what each of them wants. I mean, let's take typically an issue that I'm frequently dealing with, spousal maintenance. It's the sort of, how much, how long discussion. And of course, you unbundle that spousal maintenance can come in various forms. You can have a clean break, capitalized, term with a section 28(1)(a), etc., etc., etc. And it's unresolved. It's gone out to mediation, and that's been unable to resolve it. I don't know that coming back in to one lawyer, I mean, it could be helpful that it comes back into one lawyer and they discuss perhaps what happened in the mediation, whether that moved them a little further. One of the things I do, because I work entirely now in the out of court space as a mediator and a parenting coordinator, is on these types of issues, particularly discrete issues, is I will consider then bringing in often a barrister, someone who sits at as a deputy district judge, and I'll bring them into the mediation to give an early neutral evaluation. So they will have had a certain set of papers from me. The particular person will be agreed with the mediating couple and possibly their solicitors if they have retained solicitors. They will come into the mediation setting, so the conversation is subject to the mediation principles. And we have a conversation, and they may ask some questions, and they'll give an indication on the facts of their case that if it went before them on an overcast Thursday afternoon, what they would be likely to do. It's always worked in settling one of my cases. And again, if things get stuck, I think we have to think as practitioners, how do we try and unstick people where then they can at least have agency and make their own decisions rather than it going out to arbitration or to the court. Another way would be the hybrid way of working, where I bring the solicitors into the mediation process, and where, in accordance with the hybrid mediation model, I'm able to hold confidences in terms of the negotiations. So I can't hold any confidences in terms of for me data, the sorts of things that one would expect to be shared as between the couple, but I can hold competencies in the negotiations. Often I will have a three-way Zoom with the lawyers where, and I often say this is a little bit like sausages, perhaps, you know, you're quite happy with the end product, you don't particularly want to watch the process. We'll have a professional three-way, and that can be helpful to explore areas of law and different approaches. That has often been enough to tip a case towards settlement. Bringing the lawyers into the meeting has often been enough. You know, maybe the way I work, that I, you know, I'm always looking at ways to try and find a resolution. I have quite a high success rate. I think in mediation for me, when perhaps it gets so far that me referring out to one lawyer where the couple take legal advice could be enough then for them to come back into mediation for that to settle the case. So I think there are ways for us as different practitioners offering different processes to work together in a multidisciplinary way, but one which doesn't leave the couple feeling as though they're being pushed from pillar to post, because that's what people often say is not helpful to them, that they sort of pushed here, pushed there. If we have professional connections where we can refer them seamlessly one to the other, so it looks all the time as though they're being held by perhaps one or two professionals, I think we can find ways to resolve impasse. Did I see there was a second question? Oh, and Rita qualifying her first question, I meant to say thank you. Well, thank you for the thank you. I hope that answered the question, Rita, and there are some names here that aren't known to me. There are some that are known. You know, if you are interested in just learning more about this, I would say look at what some of these firms have offered. It's on their websites. They've got their particular products, their particular processes and ways of working. And you know, you can read their FAQs, etc. I suspect the conversation will continue. The information is on the resolution website. Again, I believe they're not behind the members section in terms of the documents. And if there are any further questions or documents that I can help with, please feel free to contact me. I suspect you will have people in the not too distant future, if they haven't already asked, oh, I've heard about this one lawyer way of working. I hope that this discussion webinar has been helpful to explain what this is and where it's at so far. But it won't surprise me at all if there aren't sort of on a daily basis newcomers to this space. And I expect within our own county and adjacent counties, there will be practitioners that will continue to roll out their particular models in terms of this way of working. Unless anyone has a final question, just scanning across, I don't think so. Then may I thank Helen, thank her again for the opportunity. Helen will make available the slides. Please feel free to contact me if you have any questions or are interested.
Sorry, Karen. I think
Yes.
I think another question's just come in in the Q&A
Thank
box
you.
from Nick.
So, Nick, am I misunderstanding? Who can do this? Sorry, Nick, if I've not made it clear. If you wish to use the resolution together title, then it is a requirement of resolution that you've undertaken that particular resolution together training, which I think is fair enough, because clients purchasing it, if it's branded as resolution together, they then need to be comfortable that the practitioner is steeped in this stuff and you know has had that training and development. But otherwise, the answer to the question is that this is regulated practice. This isn't mediation light or anything else. This is regulated legal advice. Anyone is able to offer this as part of the service they provide, whether they've resolution member or whatever, if they feel they are comfortable and qualified to do so, and they're insured to do so. So this is regulated advice. For those of you working in the regulated space, there is absolutely nothing to stop you working in this way, one couple, one lawyer. You need to obviously ensure that you feel comfortable to do so. You need to be quite clear in terms of the retainer and your contractual terms with your clients. You need to ensure that your insurers are comfortable. But this is mainstream regulated practice, and there is nothing to stop anyone undertaking it if that's what they decide to do. Nick, does that answer the question? I've got at 1:20 a thank you, so I'll assume it does. Okay, and this may now be the third time, you can't thank Helen too many times, the third time of thanking Helen for this opportunity. This is almost the sort of gone of final questions, and unless there are any further observations or questions, I will formally bring the seminar and the recording to an end, and the slides will make their way out to you. Thank you for the opportunity. It's interesting. It's always interesting. Let's watch this space and have a good day. Bye-bye now.